Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Lots of asylum this week, with some wins, including good law on motions to reopen. We're going to start, however, with what will hopefully be the last precedential decision to ever be issued by a Trump Attorney General. Happy Inauguration Week. It cannot come soon enough. Our first case this week is, I believe, a first. A precedential immigration decision issued by an acting attorney general. In this case, acting attorney general Rosen, 6 days before a new president is inaugurated. And it's no minor decision. The acting attorney general has reaffirmed and reissued none other than Matter of A.B. Matter of A.B., of course, was then Attorney General Jeff Sessions' big decision on particular social groups, specifically domestic violence-based claims, and had vacated the BIA's decision in Matter of ARCG, which had found cognizable the particular social group married women in Guatemala who are unable to leave their relationship. This second iteration of Matter of AB doesn't even cite to Matter of ARCG. Instead, it appears to be directed at the various circuit courts of appeals that have taken issue with Matter of AB since its issuance in 2018, most notably the D.C. Circuit's decision in Grace v. Barr. The facts of Miss AB's case aren't really so important in this decision, and indeed the acting attorney general didn't really discuss them anyway. Instead, he issued 3 pieces of, quote, additional clarity regarding asylum claims where an applicant does not fear a country's government or government actors. First, the acting attorney general held that notwithstanding Attorney General Sessions' discussion of a complete helplessness standard in Matter of AB, that decision, quote, did not alter the unable or unwilling standard set forth in Matter of E.A.C.A. Rather, quote, a government that is unwilling to control or protect against private harm can be said to condone it, in the ordinary sense of that word, end quote. So, practitioners, seems clear to me, the unable and unwilling to control standard that the BIA used during the 30 years before Matter of AB since Matter of E.A.C.A. is the correct standard. The acting attorney general just wants to refer to it, semantically and interchangeably it appears, as, quote, complete helplessness, end quote. Seems to intentionally muddy the waters, but so be it. According to the acting attorney general, Matter of AB didn't change anything since Matter of E.A.C.A. on unable and unwilling. Noted. But then the acting attorney general goes on to explain, I guess, what he believes Matter of E.A.C.A. said 3 decades ago. And that includes some serious limiting language. For example, and although asylum case law often requires a focus on the specific facts of a particular case, the acting attorney general counsels that, quote, one should not focus narrowly on whether government efforts to protect the applicant were effective in her specific case, or focus on a few cases where perpetrators went unpunished." End quote. The acting Attorney General also intentionally and intelligently tethered, for the first time I believe, the unable and unwilling analysis to the reasonable relocation analysis, creating sort of a double burden for non-citizens to establish past persecution. Quote, "If an alien may reasonably relocate within his home country to avoid persecution, then that may show that the failure to prevent private violence is localized, and the foreign country is not itself unwilling or unable to prevent persecution." End quote. As such, mere, quote, "localized police apathy," end quote, will not satisfy the unable or unwilling to protect standard. Turning to nexus, the acting Attorney General held that to satisfy the standard, one of the 5 protected grounds under the Act, quote, 1, must be a but-for cause of the wrongdoer's act, and 2, must play more than a minor role. In other words, it cannot be incidental or tangential to another reason for the act, end quote. In so holding, the acting Attorney General took direct aim at the Fourth Circuit, under which the acting Attorney General believes, quote, "It appears to be sufficient for the applicant's protected status to be a but-for cause of the harm she suffers, regardless of whether that status is only incidental or tangential to another reason," end quote. And based on footnote 4, it appears that the acting Attorney General believes that the Fourth Circuit standard that he's disagreeing with is similar to standards used in the Seventh and Second Circuit as well. Accordingly, citing to the Supreme Court's Brand X and Chevron decisions, the acting Attorney General held that his interpretation, and not any other circuit's interpretation, applies when it comes to the unable and willing to protect standard and the nexus requirement, and that his interpretation trumps any other interpretation, including that interpretation in the Fourth Circuit or any other circuit. And the acting Attorney General is probably allowed to do this. So long as the statute is truly ambiguous on these issues, and so long as the acting Attorney General's interpretation of that statute is reasonable, Brand X holds that the Attorney General's interpretation governs. Whether acting Attorney Generals have the authority to issue precedential decision, whether the statute is truly ambiguous, and whether the acting Attorney General's interpretation is reasonable will be the landscape upon which this decision is challenged in the future. Attorneys General are powerful things under immigration law, a fact that the Biden administration would do well to remember. At the end of the day, this is a well-written and well-thought-out decision designed to make it very, very difficult for non-citizens to obtain asylum. If that were not enough, the acting Attorney General included a terrifying footnote about what the proposed, and currently temporarily enjoined, new asylum regulations would define as persecution. Hopefully, the incoming Biden administration agrees with many in the immigration world and many federal judges that the decisions and regulations such as these do not reflect American values and should be vacated. And that is matter of AB. Sticking with asylum, we have Amiri v. Rosen, published by the First Circuit on January 11th, 2021. Mr. Amiri is from Iraq. He lived in refugee camps in the 1990s, but eventually made his way to the United States, becoming a lawful permanent resident in 1994. He has 2 U.S. citizen children. During the war in Iraq and thereafter, he worked as a paid contractor for the United States Army. And in that role, he educated U.S. soldiers about Iraqi customs and practices as they prepared for their deployment, traveling to Iraq at least 3 times in this and in personal capacities. But he obtained a larceny conviction in 2015, and upon his return from Iraq on one of these trips, DHS deemed him inadmissible for his conviction, notwithstanding his LPR status, likely because it deemed his larceny conviction a CIMT, that thereby made him an applicant for admission under I&A Section 101-813C v. Let this be a warning to LPRs with criminal convictions. Be careful traveling, even if the conviction doesn't make you removable, it can prevent you from returning. Mr. Al-Amiri filed for asylum and related relief in removal proceedings, claiming to fear insurgents in Iraq due in large part to his work with the U.S. Army. Sounds legit to me. The immigration judge and the BIA denied, but the First Circuit thought that the claim was legit too, and reversed and remanded. The First Circuit held that the BIA was wrong in finding that Mr. Al-Amiri failed to establish a nexus between a protected ground and the harm he feared. Although the BIA rejected the particular social group, quote, Americanized or westernized individuals, end quote, it failed to consider Mr. Al-Amiri's more narrow particular social group of, quote, Iraqis who provided assistance to the U.S. military in connection with that war, end quote. The First Circuit also rejected the BIA's finding that Mr. Al-Amiri did not have a reasonable fear of return to Iraq. The BIA apparently believed his fear unreasonable because only one neighbor in Iraq knew that Mr. Al-Amiri had a connection to the U.S. government. But the First Circuit rejected this because Mr. Al-Amiri did not, quote, premise his fear of harm on the potential discovery by others of beliefs or opinions that were held but never openly expressed, end quote. Rather, he, quote, premises his fear on the discovery of conduct in which he openly engaged, and that is well documented in official records, end quote. And there are a lot of individuals with ties to Iraq in the U.S. and abroad who know about his work with the U.S. government. This is particularly important because to obtain asylum under BIA precedent, Mr. Al-Amiri need only show that a potential persecutor, quote, could become aware of the trait that could give rise to persecution, end quote. So the First Circuit remanded. I've got one more quote and a note. Something to remember. The IJ and the BIA in this case also found that Mr. Al-Amiri's fear was not reasonable because of his travels to Iraq. But the First Circuit rejected that logic here because, quote, the fact that he was able to conceal his employment history during time-limited trips to Iraq does not mean that he will be able to do so for months and years on end, end quote. Good to know. And just an aside for listeners who are curious, Mr. Al-Amiri did not apply for LPR cancellation of removal under I&A Section 240AA, a far easier form of relief to obtain than asylum, because he already received that relief in 2011, following a different conviction. And that is Al-Amiri v. Rosen. Sticking with asylum and skipping to the 9th, we have Hussein v. Rosen, published on January 11th, 2021. This is another case about asylum and related relief, and includes a discussion about due process rights of pro se respondents. Mr. Hussein is from Pakistan, specifically a town in the lawless, federally administered tribal areas, known as FATA, bordering Afghanistan. He represented himself in removal proceedings, where he testified that the Taliban burned down his jewelry store and other buildings in an attack on his hometown in 2007, and attacked a convoy that he was traveling in 2012. Mr. Hussein did not appear to have provided evidence that he was specifically targeted at any time before he left Pakistan in September 2015. The IJ and then the BIA denied asylum and withholding of removal relief and denied protection under the Convention Against Torture. A large blue-chip law firm took the case pro bono on petition for review, and the Ninth Circuit affirmed the BIA's decision. The court held that the generalized violence by the Taliban was not targeted at Mr. Hussein, and therefore he did not suffer past persecution. The Ninth Circuit also held that on the record before it, the Pakistani government is not unable or unwilling to control the Pakistani Taliban, and that additionally, Mr. Hussein did not show that he could not reasonably relocate outside of his town in the FATA. Although Mr. Hussein appeared without an attorney before the immigration judge, the Ninth Circuit also held in this case that IJs do not violate a pro se non-citizen's due process rights so long as the IJs provide a non-citizen, quote, the opportunity to testify. IJs need not, indeed cannot, essentially act as Sherpas for pro se petitioners, guiding them in making their case, end quote. In so holding, the Ninth Circuit distinguished and took some serious shots at its oft-cited 2000 decision, Jacinto v. INS. So Mr. Hussein lost, but I have combed the footnotes, and here's what I found. At footnote 3, the court goes on at great length to explain why a letter documenting a threat to Mr. Hussein specifically does not constitute past persecution, concluding by stating that, quote, in contrast to this one anomalous bare assertion in the letter, Hussein's testimony provides substantial evidence that neither he nor his family were ever the specific targets of the Taliban's generalized violence, end quote. This rationale, rejecting credible record evidence in favor of a respondent's credible testimony, is certainly helpful and citable in the reverse situation, where, say, DHS submits a vague or general country condition evidence that purports to contradict a respondent's credible testimony. This footnote appears to be saying that in such situations, a non-citizen's credible testimony should trump. Next, and although the Ninth Circuit denied Mr. Hussein's due process challenge, it did state, citing to its prior precedent, that in considering whether a non-citizen received due process, quote, the critical question is whether the IJ's actions prevented the introduction of significant testimony, end quote. That is a standard that can certainly be met in some cases that I know, particularly as IJs during the Trump administration have been incentivized and perhaps required, due to high case completion requirements, to shorten and expedite individual hearings. And finally, this case can also be cited for the proposition that when an IJ asks, quote, leading questions, end quote, and otherwise does the job of either party, including DHS, the IJ improperly changes her role, quote, from that of an impartial adjudicator to effectively being an advocate, end quote. And that is Hussein v. Rosen. Moving to the Eighth Circuit, we have Hassan v. Rosen, published on January 15th, 2021. This is a short case about deferral of removal under the Convention Against Torture, and it involves yet another Somali individual who the U.S. tried to physically remove a couple of years ago on a failed repatriation flight, leading to federal litigation. Mr. Hassan is from Somalia and was ordered removed to that country. But eventually, the Board of Immigration Appeals granted his motion to reopen to allow him to apply for deferral of removal under the CAT, which necessarily meant that Mr. Hassan established a change in country conditions in Somalia material to his case since his removal hearing. On remand, however, the IJ denied CAT protection, and the BIA affirmed that denial. The agency rejected Mr. Hassan's arguments that the Somali government would torture him for belonging to the minority Baghdadi clan, and that Al-Shabaab would torture him for minority clan membership, being westernized, and having been on that failed repatriation flight. And the Eighth Circuit affirmed. It noted that rather than being a persecuted group, the record indicates that the Baghdadi clan is actually a, quote, noble subclan, with major representation in the Somali government. Turning to whether the Somali government would acquiesce to any torture from Al-Shabaab, the Eighth Circuit noted that it recognizes the willful blindness standard for CAT protection, and that the, quote, inquiry into whether a government acquiesces centers upon the willfulness of a government's non-intervention, end quote. Interesting and potentially helpful way to put it. But applying that standard in this case, the Eighth Circuit held that the, quote, Somali government is actively fighting to control Al-Shabaab, has considerably reduced Al-Shabaab's military capacity, and has demonstrated a willingness to fight terrorism, end quote. Somalia's amnesty program for Al-Shabaab members does not show otherwise, because Somalia is using that program to, quote, encourage defections as part of its fight against Al-Shabaab, end quote. Mr. Hassan, therefore, did not succeed on his petition. And that is Hassan v. Rosen. Shifting gears a bit, we have E.A.C.A. v. Rosen, published by the Sixth Circuit on January 12, 2021. This is a case about motions to reopen in absentia orders of removal, and it's a rare circuit win on the issue. Miss E.A. is a child from El Salvador, which is why the court referred to her by her initials only. She entered the U.S. as an unaccompanied minor at 12 years old and was then released into the custody of her mother in New York. The family relocated to Arkansas, and with the assistance but not representation of Catholic Charities, Miss E.A., pro se, notified the immigration court of her changed address and changed venue to the immigration court in Memphis, Tennessee. A different pro bono attorney service then filed an appearance on her behalf, but after the first hearing in immigration court, pro bono counsel moved to withdraw because Miss E.A. had moved out of the pro bono organization's geographic jurisdiction and counsel had left the pro bono entity. Now, and without representation, Miss E.A. did not appear for her second hearing in June 2018 and was therefore ordered removed in absentia. Catholic Charities then took up the case pro bono and filed a motion to reopen for Miss E.A. in November 2018. Arguing that a whole bunch of things had prevented Miss E.A., who remember by that time was only 13 years old, from attending her hearing, and that in totality, those things constitute exceptional circumstances that should excuse her failure to appear at the June 2018 hearing. Although the motion was timely, because it had been filed within 180 days of the June 2018 hearing, the IJ and then the BIA denied it. Despite the, quote, heavy burden that non-citizens have to succeed on a motion to reopen petition for review, the Sixth Circuit reversed and remanded. An in absentia order of removal can be rescinded and proceedings reopened, based on a showing, within 180 days of the order, that the failure to appear was based on exceptional circumstances beyond the control of the non-citizen. Now, the regulations are pretty strict on just what constitutes exceptional circumstances, stating that they include circumstances, quote, such as battery or extreme cruelty to the alien or any child or parent of the alien, serious illness of the alien, or serious illness or death of the spouse, child, or parent of the alien, but not including less compelling circumstances, end quote. But in the Sixth Circuit at least, the analysis still requires a totality of the circumstances approach. Here, the Sixth Circuit held that the BIA was wrong for two reasons. First, the Sixth held that the totality of circumstances was indeed exceptional in this case. Those circumstances included the fact that, of course, Miss E.A. was a minor, that she and her mother had moved back to New York shortly before the hearing, that her mother had given birth shortly before the hearing, that her mother tried and failed numerous times to obtain counsel to help change Miss E.A.'s address back to New York, and that Miss E.A., as a 13-year-old non-citizen, was simply not able to travel from New York to Memphis for her June 2018 hearing. The Sixth Circuit held that, in particular, Miss E.A.'s mother's, quote, recent childbirth is a serious medical condition that supports reopening, end quote, even though Miss E.A.'s mother, of course, knew that she was pregnant before the hearing. The Sixth Circuit said that did not matter. It's still an exceptional circumstance. And although not determinative, the Sixth Circuit did hold quite powerfully that, quote, under the totality of the circumstances, E.A.'s young age is an important factor in determining whether exceptional circumstances exist, end quote. The Sixth Circuit took particular issue with the fact that the BIA seems to have, quote, faulted a 13-year-old girl for not finding someone to drive her from New York to Memphis and then back, end quote. Finally, the Sixth Circuit held that the BIA erred by failing to consider the fact that Miss E.A. appeared eligible for special immigrant juvenile status, which could eventually result in a green card, thereby giving her a reason to appear in court for her hearing. In so holding, the Sixth Circuit held that Miss E.A. was not, quote, required to present prima facie evidence that she was eligible for immigration relief as part of her motion to reopen, end quote. Although other motions to reopen do indeed require a prima facie showing of relief eligibility, the in absentia regulations require no such showing. So Miss E.A. gets her day in court. Congratulations to Rachel Nagar and the Catholic Legal Immigration Network on another great win. Here are a few more observations. First, I think it's worth mentioning that most, if not all, of the facts in this case establishing exceptional circumstances came from attorney and client affidavits. So remember to submit affidavits in these motion to reopen cases, because the mere arguments of counsel are never evidence in immigration court. But affidavits are. And, at the risk of quoting the obvious, here's something to remember for motions to continue where relevant. Quote, "Childbirth is a serious medical event that necessitates a recovery period." End quote. Finally, as the Sixth Circuit notes in a footnote, after the BIA ruled, Ms. E.A. was deemed abandoned by a New York State court. USCIS approved her special immigrant juvenile status application, and a visa became available for Ms. E.A. per the visa bulletin. Special immigrant juvenile status procedures are quite complex, and kudos to practitioners who practice in that world. But succinctly stated, it looks like that, due to this decision, Ms. E.A. is on a path to a green card. Congratulations to all. And that is E.A.C.A. v. Rosen. Next is Zelaya Diaz v. Rosen, published by the Seventh Circuit on January 15, 2021. This is the first of two Seventh Circuit cases this week, and it's a historical case about administrative closure and repapering. Mr. Zelaya Diaz entered the U.S. unlawfully in 1995 and was placed in what at the time was called deportation proceedings, through service of what was at the time called an order to show cause, or OSC. He didn't appear for his hearing and was ordered removed, and he physically departed the U.S., re-entering in 1998. He was discovered by DHS in 2014, and, most likely to prevent his imminent removal, he moved the immigration court to reopen his in absentia order of removal based on a lack of notice in 1995. And the IJ granted the motion. In reopened proceedings, Mr. Zelaya Diaz moved the IJ to administratively close proceedings, which takes a case off the IJ's active docket. Mr. Zelaya Diaz wanted to administratively close his case in order for DHS to repaper him, which essentially means serve him with a notice to appear, or NTA, which would then restart removal proceedings. Mr. Zelaya Diaz wanted this to occur because he stopped accruing presence in the U.S. when he was served with the OSC in 1995, even though he's lived in the U.S. for over 20 years. Because he stopped accruing presence in the U.S. in 1995, he is not eligible for relief, such as suspension of deportation or cancellation of removal, that require a certain amount of continuous presence in the United States. But if DHS served him with a new NTA, he would become eligible for cancellation of removal, because he would then be credited for all of the time in the U.S. since 1998, meaning that he'd satisfy the 10-year continuous residence requirement for cancellation of removal. Per DHS policy memos, DHS is generally supposed to repaper individuals like Mr. Zelaya Diaz in this situation, provided that they have qualifying U.S. citizen or LPR relatives, and provided that the non-citizen doesn't have criminal convictions that bar cancellation of removal. Thank you, Kurzban's sourcebook, for the information. The problem is that by the time Mr. Zelaya Diaz needed repapering, Attorney General Jeff Sessions had taken away administrative closure as an option that immigration judges can utilize in matter of Castro Tum. And DHS can't repaper someone if their proceedings are active and ongoing. The IJ therefore denied the motion to administratively close proceedings and granted Mr. Zelaya Diaz voluntary departure to Mexico, which essentially means that he needs to leave the U.S., but because of his unlawful presence, he'll be barred from coming back for at least 10 years. The BIA affirmed. But the Seventh Circuit was having none of that, because last year in Meza-Morales v. Barr, and to be fair, after the BIA's decision in this case, the Seventh Circuit held that matter of Castro Tum is, quote, contrary to law, and that immigration judges and the BIA are not precluded from administratively closing cases when appropriate, end quote. The Seventh Circuit, therefore, quote, effectively reinstated the prior board precedent in matter of Avatesian and matter of WYU, end quote, which allows for administrative closure. The Seventh Circuit sent the case back to the BIA for the BIA to consider whether administrative closure was warranted in light of the factors delineated in those cases. Congratulations, Mr. Zelaya Diaz. Here's a bit more on circuit arguments. Here's an interesting facet of the case for circuit practitioners to remember. Although the Seventh Circuit granted the petition, it rejected Mr. Zelaya Diaz's first argument based on the Supreme Court's I&N doctrine. The I&N doctrine holds, quote, generally, that federal agencies are required to follow their own regulations and some other formally adopted procedures, including those that govern exercises of an agency's discretion, end quote. But according to the Seventh Circuit, quote, the I&N doctrine generally does not apply to an agency's internal memoranda, at least those that are neither designed to protect individual rights nor intended to have the force of law, end quote. In this case, the internal DHS memorandum for repapering did not reach the level of formality or substantive importance in protecting individual rights such that the I&N doctrine applied. But if they did, the doctrine would apply. So remember the argument. And that is Zelaya Diaz v. Rosen. Our last Seventh Circuit case, and last case of the episode, is Meraz-Saucedo v. Rosen, published by the 7th on January 15th, 2021. Mr. Meraz-Saucedo is from Mexico, has lived in the U.S. since 2004, and has 2 young U.S. citizen children. DHS served him with an NTA in 2013, i.e. before he had obtained 10 years continuous presence in the U.S. But the NTA did not contain the date and time of his first hearing. He received a notice of hearing with that information from the immigration court shortly thereafter. Precluded from non-LPR cancellation because he didn't have the requisite 10 years, Mr. Meraz-Saucedo applied only for asylum and related relief, based on threats that he and his family had received from the Sinaloa cartel due to his father's refusal to grow marijuana in Mexico. And indeed, his father was beaten and his brother and niece were kidnapped in 2013, and the whole family was threatened with murder. But the IJ denied asylum relief, withholding of removal, and cat protection. During the pendency of appeal to the BIA, the Supreme Court issued Pereira v. Sessions, which held that an NTA lacking the date and time of a non-citizen's first hearing does not stop the cancellation of removal 10-year clock. Newly eligible for cancellation due to Pereira, Mr. Meraz-Saucedo filed a motion to remand to the immigration judge, which the BIA denied based on the BIA's split decision in matter of Mendoza-Hernandez, which held, after Pereira, that service of a notice of hearing stops the clock even though the statute expressly requires that the date and time of the initial hearing be in the NTA. The 5th and 6th Circuits have agreed with the BIA and Mendoza-Hernandez. The 3rd and the 10th Circuits have disagreed, and the 9th Circuit has gone en banc on the issue. And the entire mess is currently before the Supreme Court this term. Here, the 7th Circuit decided not to enter the fray, because it held that Mr. Meraz-Saucedo failed to timely make the argument all those years ago in his removal proceedings pre-Pereira. Harsh. Turning to asylum, the 7th Circuit affirmed the BIA's denial. It cited 2 decisions last year that in order for membership in a family to constitute a nexus to a protected ground, family membership must be, quote, the motivation for the persecution, end quote, and that here, that was not the case. Rather, the evidence showed that the harm to Mr. Meraz-Saucedo's family was motivated by the cartel's financial incentive. Not only that, but the rest of his family has lived peacefully in Mexico since 2013. And for similar reasons, the 7th Circuit affirmed the denial of withholding and protection under the Convention Against Torture. But here's one more thing to remember. In this case, like so many cases, the 7th Circuit summarily dismissed the withholding claims because, quote, since an asylum claim has a lower burden of proof, failure to establish eligibility for asylum means it is unlikely that Meraz-Saucedo can prevail on his withholding of removal, end quote. But that's not necessarily the case, especially where here the asylum denial was premised primarily on a failure to establish a nexus to a protected ground. i.e. that familial membership was one central reason for the persecution that Mr. Meraz-Saucedo feared. And the reason that it's not necessarily the case is because, and at least in the Ninth and recently in the Sixth Circuit decision, Guzman-Vasquez v. Barr, a protected ground need only be a reason for the persecution feared in order to satisfy the nexus requirement for withholding, whereas asylum requires that a protected ground be one central reason. The only way to get a circuit like the Seventh Circuit to decide this legal issue is to argue it before the IJ and the BIA. So preserve this nexus argument in your withholding cases and try to make some good law. And that is Meraz-Saucedo v. Rosen. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.